What I'm about to explain wasn't meant to surface publicly, at least not yet. For days, it sat buried behind sealed filings, redactions, and procedural language most people never read. But once fragments began appearing in court dockets late last weekend, it became clear that something extraordinary had happened. The United States Supreme Court has issued a direct command to Donald Trump. Not advice. Not guidance. A command, with consequences attached. This wasn't a routine ruling or a symbolic gesture. According to the language revealed so far, the court has demanded compliance and attached a penalty that is rarely used at this level of the judiciary. If the order is ignored, enforcement follows. And that enforcement includes the possibility of detention until compliance is achieved. That alone makes this situation unprecedented in modern American politics. The order itself bears the signatures of 6 justices. It was finalized nearly 2 weeks before the public ever saw a word of it. The only reason it came to light at all is because a procedural filing in an unrelated matter forced a redacted version into the public docket. What's visible is limited, but what is visible is enough to raise serious questions about what's happening behind closed doors. At the center of the order is a demand for materials Trump has repeatedly said do not exist. The court, however, states that it has received independent verification that these materials are real, accessible, and known to Trump. The refusal to produce them, according to the court, now constitutes contempt. The wording matters here. The order directs Trump to produce specific documents, recordings, and communications tied to a previously issued subpoena, identified only by number in public filings. The deadline is strict. 14 days from issuance. No extensions guaranteed. And the consequence for failure is referral to federal enforcement authorities, including custodial detention until compliance. That phrase, *custodial detention pending compliance*, is not symbolic. It is not a fine. It is not a warning. It is a legal mechanism designed to compel action, not punish past behavior. In plain terms, comply or remain detained until you do. The subpoena at issue is connected to the broader January 6 investigation, but not to the events of that day itself. Instead, it focuses on a narrow and critical window, the 72 hours leading up to certification. The materials sought include communications between Trump and several individuals whose identities remain redacted. What we do know, from adjacent filings, is that this group includes high-ranking military officials, at least one sitting member of Congress, and private citizens with no formal government role. That alone reframes the scope of the investigation. Adding to the gravity is a sworn declaration from a senior archivist at the National Archives. According to this statement, certain recordings were discovered during a routine security review of materials transferred from the White House. These recordings were not logged in standard systems and were found on a standalone device inside a mislabeled storage container. The archivist describes them as conversations of significant legal and historical importance. Trump's legal team has denied all of this, claiming the device was unusable, the archivist mistaken, and the contents privileged. But the Supreme Court explicitly rejected those arguments. And that's where this story truly begins. If the court is willing to go this far, the next question is obvious. What exactly did they find, and why are they convinced Trump knows it exists? That's where Part 2 takes us. The Supreme Court doesn't issue ultimatums lightly, especially not to a former president. So when the justices dismissed Trump's claims outright, it sent a message that something more than speculation was at play. Buried in a footnote of the order is a key detail that changes the entire narrative: independent forensic analysis. According to the court, experts confirmed that the device in question was functional, intact, and capable of storing the recordings described by the National Archives. Even more significant, the court ruled that claims of executive privilege do not apply if the material involves potential interference with constitutional processes. That's not a trial court interpretation. That's the Supreme Court drawing a line. The timeline adds weight to the decision. The device was discovered more than a year ago. The Department of Justice was notified shortly after. A grand jury was convened. Subpoenas were issued. Legal challenges followed. Appeals climbed the ladder. And after more than a year of delay, the highest court in the country intervened directly. Courts move slowly, but they do not move blindly. What pushed this case over the edge was a second document that surfaced at the same time as the order. This one was a letter from the Solicitor General's office to the Supreme Court clerk. Though marked for confidential litigation use, It appeared, accidentally, in a public filing connected to a separate case. That letter references a sealed, in-chambers hearing attended by all 9 justices. The reason? Trump's legal team requested an emergency stay, arguing that compliance would cause irreparable personal and political harm. The government's response, summarized in the letter, was devastating. According to the Solicitor General, 2 witnesses with direct knowledge of the recordings testified under oath. Both confirmed that Trump was aware of the recordings, had access to them, and had discussed their contents with advisors within the past year. Their testimony was supported by electronic records, metadata, text messages, and calendar entries. This wasn't hearsay. It was corroborated evidence. One passage stands out. A witness testified that Trump said the recordings would be a problem if they were ever heard. Not that they were fake. Not that they were misunderstood. That they would be a problem. The same witness stated that Trump directed the device to be kept secure and ordered that no copies be made. That's not confusion. That's intent. The letter also references a photograph submitted during the sealed hearing. It shows a digital recorder sitting on a desk inside an office later identified, through background details, as being located at Mar-a-Lago. The timestamp places the image on a specific date and time. Security logs and phone records confirm both the witness and Trump were in the building at that moment. Trump's attorneys have dismissed the image as misleading. But the government argues the timing and corroboration tell a different story. By this point, the picture is clear. Testimony, digital evidence, photographs, metadata, and a year-long paper trail. That's why the court stopped entertaining delays. Now that the evidence is established, the next question becomes unavoidable. What happens if Trump refuses anyway? Part 3 breaks down the enforcement mechanism and why it's shaking the legal world. The Supreme Court's order gives Trump 14 days. As of now, that clock is already ticking down. If the materials aren't produced by the deadline, the order authorizes federal marshals to take Trump into custody, not as a criminal defendant, but as a contemner. That distinction matters legally, but not practically. This would be civil contempt, not a criminal charge. There would be no trial, no verdict, no sentencing. The detention would exist for one reason only, to force compliance. The moment the materials are produced, the detention ends. Until then, it continues. Historically, this remedy is extremely rare, especially at this level. Courts reserve it for cases where someone is actively obstructing justice and where no lesser enforcement tool has worked. The Supreme Court itself has invoked it only a handful of times. The language of the order makes clear that the justices believe they've reached that point. Trump's legal team has already signaled its next move: emergency motions, constitutional arguments, and claims of overreach. But the problem is simple. The court has already addressed those arguments and rejected them. The order explicitly states that Trump has been afforded every procedural protection available. One line near the end of the document is especially telling. The court states that further obstruction will be met with the full enforcement powers available. That is not the language of negotiation. That is the language of finality. If enforcement occurs, Trump would likely be held in a federal detention facility. Not a prison, but not his home either. His lawyers could file motions. They could seek hearings. But none of that automatically stops detention. Courts do not pause contempt enforcement simply because new filings appear. Politically, the implications are explosive. A former president detained by order of the Supreme Court would dominate global headlines instantly. Every elected official would be forced to choose a side, not between parties, but between compliance with the judiciary and loyalty to Trump. Supporters would call it persecution. Critics would call it accountability. But the institution issuing the order complicates that narrative. This is not a prosecutor's office. This is not a congressional committee. This is the Supreme Court, an institution with a conservative majority that includes justices appointed by Trump himself. That fact alone undermines claims of partisan motivation. Beyond politics, this moment raises a foundational question. Does the rule of law apply equally to everyone? If a private citizen refused a court order this long, detention would be routine. The only reason this feels shocking is because of who is involved, not because of what the law allows. The court appears determined to answer that question decisively. But enforcement is only part of the story. The real issue is why these recordings matter so much. In Part 4, we look at what's believed to be on them, and why the government is unwilling to back down. The government hasn't publicly released the contents of the recordings, but court filings offer important clues. According to the subpoena and related documents, the conversations involve discussions about electoral certification, constitutional authority, and the role of key government officials during a disputed outcome. These are not casual conversations. They are described as strategic discussions. What's especially telling is that the subpoena doesn't just demand the recordings themselves. It also demands every communication about them: texts, emails, notes, and internal discussions. According to the Solicitor General's letter, none of that has been produced either. That suggests something more than oversight. There are also unconfirmed reports, clearly labeled as such, that at least one person involved in the recordings has already cooperated with investigators. If true, the government likely knows the substance of the conversations already. But summaries are not the same as audio. Audio is immutable. It cannot forget. It cannot change its story. That's why recordings carry such weight in court. They don't need interpretation. They don't require credibility assessments. They simply play. If Trump believed the recordings were harmless, there would be little incentive to fight this hard for this long. The refusal itself raises questions, especially when combined with testimony suggesting he believed the recordings would be damaging if heard. This pattern isn't isolated. It mirrors other legal battles involving Trump: documents retained at Mar-a-Lago, testimony delays, privilege claims, and prolonged resistance followed by forced compliance. The strategy has been consistent: deny, delay, and defy. The difference here is the venue. There is no higher court. No further appeal. This is the end of the legal road. And that's what makes this moment historic. If the recordings are produced, they could reshape not only the January 6th narrative but multiple ongoing investigations. Statements made in one context can become evidence in another. Once released, they cannot be contained. That reality explains the stakes. So where does this all lead? In Part 5, we look at what happens next, and why the outcome will echo far beyond one man or one case. Over the next several days, the legal system will reveal something fundamental about itself. Either the order will be obeyed, or it will be enforced. There is no third option. Trump's attorneys will almost certainly file more motions. They will argue constitutional violations, political motivation, and lack of jurisdiction. But those arguments have already been considered. That's why the order exists. If compliance happens, the recordings will enter evidence streams that could affect multiple investigations. If it doesn't, enforcement follows. And that enforcement would mark one of the most consequential moments in American legal history. This isn't about punishment. It's about precedent. If a former president can openly defy the Supreme Court without consequence, then the authority of the judiciary collapses. If he cannot, then the rule of law is reaffirmed in the strongest possible way. That's why this moment matters, not just for Trump, but for the country. Every citizen lives under court authority. Subpoenas are not optional. Orders are not suggestions. The only reason this feels extraordinary is because of status, wealth, and power. Strip those away, and the law is clear. Whatever happens next will be studied for decades. It will shape how future leaders view accountability. And it will determine whether "no one is above the law" remains a principle or becomes a slogan. We are watching history unfold in real time. The deadline is approaching fast. When it expires, we'll learn whether power bends the law, or the law finally bends power back.